3, 2, 1.
Welcome to this licensing hearing. The first item on the agenda is to elect a chair, and I understand that members would like to elect Councillor Melly to chair the meeting. Is that agreed?
Agreed.
Thank you. I'll hand over.
All right, thank you, Fiona. Good morning, everyone. Welcome to members, officers, representatives, and anyone else participating in this remote hearing or watching live at home. A recording of this hearing will also be made available to view online later. Right, agenda item 2, introductions. There's 3 of us sitting on this licensing hearing panel. I'm Councillor Melly. I will be chairing today's meeting, and we also have Councillor Hook and Councillor Galvin sitting on the panel with me today. There's also a Democratic Services Officer, Fiona Young, and a Legal Officer, Victoria Wardby, in attendance during the meeting. I'll just go through and ask everyone else to introduce themselves, please, and name any witnesses that you've brought with you. So first, the Licensing Officer, Helen Sefton.
Hello, good morning, everybody. Yes, I'm Helen Sefton, and I'm the Senior Licensing Officer for the Licensing Authority.
Right, thank you, welcome. The applicant, or anyone who's here representing the applicant.
I'm Megan Wharton from Upton Fawcett with Mr. Ferrioli, who is the applicant. He's with his son, Daniel Ferrioli, and I also have a trainee with the firm present as well.
All right, thank you, welcome. Representatives, first, Councillor Myers.
Councillor Myers, Clifton Ward.
All right, thank you, welcome. And another representative, Sandra Brannigan.
Yes, good morning. My name is Sandra Brannigan. I am representing the person who's made a representation at the representation number 10 on page 75 of the agenda. Just for the purposes of just complete transparency, I am an employee of City of York Council. I'm a solicitor employee of City of York Council, but I am here purely in a personal capacity. I'm not here acting as a solicitor. I'm representing one of the representors.
All right, thank you, welcome. Okay, I think that's everyone. So agenda item 3.
Councillor Melly, can I just,
Yep.
before Charles Holland beats me to it,
Yep.
Charles Holland's here as counsel for the applicant as well.
Ah, right, sorry, Charles.
Good morning, Chair. No, sorry, we're taking advantage of the benefits of remote working to be in 2 different locations. So I'll be presenting the application on behalf of the applicant.
All right, thank you, and sorry I missed you off. Is that everyone now? Yeah, can I move on to agenda item 3? Great, all right. Agenda item 3 is declarations of interest. So does anyone on the panel have any interests to declare? No, I'm seeing shaking heads. All right, great, me neither. So agenda item 4, exclusion of press and public. I'm going to propose that in the usual way, the press and public be excluded from the meeting during the subcommittee's deliberations after the hearing and during the decision making. And that's because it considers that the public interest in excluding the public outweighs the public interest in that part of the meeting taking place in public under Regulation 14 of the Licensing Act 2003, Hearings Regulation 2005. We haven't had any other evidence or representations of a sensitive or confidential nature submitted, so I don't think there'll be any other reason to hold anything in private session. Is it okay to resolve that?
Great.
All right, great. Agenda item 5, minutes. We've had some minutes circulated as an agenda supplement for a licensing hearing held on the 11th of April 2022. Are we happy to approve those minutes? Great, yeah, I've read them and I'm happy they're an accurate record, so thank you for that, Fiona. So agenda item 6, the application. We are going to determine an application by Clifton Bridge Hotel Limited for a premise licence at the Clifton Bridge Hotel, 23 Water End, York. So you should have all seen a document outlining the procedure for the hearing. It's on pages 1 to 6 of the agenda pack. One small change to that procedure. We're not going to announce our decision after determination in this public meeting. We'll end this meeting at the end of the hearing, and then you'll be informed as soon as possible after the decision is made. We won't come back into this public hearing to announce the decision today. So in summary, the running order of proceedings is that the licensing officer will present their report. Then I will invite each party one by one to ask the licensing officer any questions. Then I will invite each party in turn to present their cases and call any witnesses. And each party will have the opportunity to ask questions after each presentation. And the subcommittee, the panel, will also be able to ask any questions of the parties after each presentation. And then finally, the parties will each be invited to summarise their case, and we'll have the opportunity to seek any final points of clarification, and then we'll go into our private session for deliberations and to make a decision. So do all the parties understand the procedure for this hearing this morning? Any questions? No? Oh, great. All right. So we'll move on. Could the licensing officer, Helen Sefton, please present your report?
Yes, thank you, Councillor. Can everybody hear me okay?
Yep.
Lovely. So today we're here for an application for the grant of a premises licence made by Clifton Bridge Hotel Limited. And the nature of the application is to allow for the sale of alcohol at a 14-bedroom hotel, which has a restaurant seating 43 customers. The hotel also includes an outside area for up to 20 people. The application is for the sale of alcohol only, and it is from 12 noon to 11 p.m. every day. A copy of the application and the plans are at Annex 1. An overview of the circumstances in which entertainment activities are not licensable can be found at Annex 2. This hotel was previously licensed with a different operator, but that license was suspended in 2012 due to non-payment of the annual fees. And subsequently, the license then lapsed in 2018 due to the death of the previous license holder. A new application for the grant of a premises license was made by the current owner in October 2021, and that application was subsequently withdrawn. As part of the application, the operating schedule submitted by the applicant shows that the licensing objectives would be met as indicated in paragraph 10 of the report. This premises is not located within the cumulative impact area. I can confirm that the consultation for this application was carried out correctly, and there have been no representations from any responsible authorities. There have been 11 representations received from other persons who have objected to the grant of this licence, stating that the objectives of the prevention of public nuisance and the prevention of crime and disorder would be compromised if this licence is granted. Their representations can be found at Annex 4. A map showing the general area of the premises can be found at Annex 5. So today the committee has the following options when making your decision. Option 1 is to grant the licence in the terms applied for. Option 2 is to grant the licence with modified or additional conditions imposed by the licensing committee. Option 3 is to grant the licence to exclude any of the licensable activities to which the application relates and modify or add conditions accordingly. Option 4 is to refuse to specify a person on the licence as a premises supervisor. And option 5 is to reject the application. And that is my report. Thank you.
Thank you very much. So we've got the opportunity now to ask some questions of the licensing officer. This is just for questions at this stage. Everyone will have the opportunity in a few minutes to speak and support, but we have 5 minutes kind of per representative for questions now. So I'll start with the applicant or anyone on behalf of the applicant.
I've no questions, thank you, Chair.
All right, thank you. Councillor Myers, do you have any questions?
Thank you, Chair. I'd just like to ask if Helen, could you outline the main differences in the applications? The first one that you received in October last year and was subsequently withdrawn. You mentioned also that the consultation was properly completed. Could you just explain around the licensing law, why or whether a licensing authority can contact previous objectors? Of course, there were a high number of objectors to the first application, and then with withdrawal, those objections did not stand for the second application. If you could just explain that for clarity, that'd be really helpful.
Okay. So the first question, unfortunately I had COVID when the last application came before us. So to give you a full answer to that one, can I research that and come back to you as to what the difference is in the two applications to give you a proper answer? So I'll certainly find that out during the hearing. The second part about the consultation. So this is a completely fresh application. So it wouldn't be possible or appropriate to contact previous objectors to this application because even though there is a second application, this is a brand new application. We wouldn't in any other circumstance contact previous objectors, whether it had been 6 months or 6 years. So it's put in a site notice at the premises, it's put in the local press, and it is up to anyone who wants to make representation to find that information out and then to contact us. So it's not possible or appropriate to sort of go back to objectors and say, would you like to object again? I don't know if that fully answers the question.
Yeah, thank you.
Do you have any other questions, Councillor Myers? Okay, thank you, Helen. If you don't mind going away and finding that information to answer that question.
I will.
Also, we will have a minute in a moment. You'll might be able to ask the applicant the same question as well when we get to that stage.
Yeah, can I ask a question?
Well, hold on a sec. Sandra Brannigan has the opportunities to ask questions first, and members of the panel will ask questions last. If that's all right, Councillor Galvin. So, Sandra Brannigan, do you have any questions to ask of the licensing officer? You have 5 minutes.
Yes, I do have a couple for me. The previous license was a hotel license, wasn't it?
It was a premises license. They don't state that they're for a hotel or bar.
But it was constrained so that it was effectively residents and food with alcohol served to residents of the hotel. It wasn't. It's totally different to the nature of what is being applied for now.
There were carried over conditions from the 1964 Licensing Act, which said that it was for residents.
So this is a totally different sort of license that is being applied for now to the previous.
The previous license was grandfather rights from the 1964 Act, so it became a premises license in 2005. But this application doesn't state anything about it being a hotel.
Yeah. Does the applicant have a personal license?
The applicant is a limited company. So the designated premises supervisor has a personal license, but the applicant is a limited company.
So do I think that Mr. Farioli is here as the applicant? He is effectively the company. Does he have a personal license, or do you know who the DPS is?
I do know who the DPS is. The DPS is Daniel Farioli. I hope I've announced that correctly, and he is correctly licensed as a personal license holder.
Oh, so he's right. Thank you. The plans, they don't show a smoking area, do they?
Just get the plans.
For anybody else who's watching along, there's plans on page 45 of the agenda pack if you're wanting to look at what's being referred to.
No, there's nothing that's called a smoking area on the plans.
Thank you. And you said in your presentation that there is a outside seating area for 20 people, but there's nothing on the plan, is there, to show seating outside? It's a very large outside seating area, and there are nothing to indicate seating or maximum number of seating out there. Just shows
there's no fixed seating on the plan. The number of 20 has come from the application, so the applicant has stated there is room for 20 people on the application.
Yeah. Well, it's a very large outside seating area, so there's room for a lot more than 20 people. Would you agree? Yeah.
I don't know. I couldn't agree. No.
And likewise, there is nothing to show fixed seating indoors and any covers to show that there are going to be, I think they say there's going to be seating for 43 indoors, but there's no seating shown or covers on the plans.
There's no fixed seating on the plan
that you've seen showing that. Okay, thank you. No further questions, thank you.
All right, great, thank you, Ms. Brannigan. So yes, time for the subcommittee if we have any questions for the licensing officer. Councillor Galvin, would you like to go first?
Yes, Chair. There has been a number of presenters that are making a case of problems in the past. Was this under the old licence? In other words, has the property in recent times, since the demise of the last licensee, presumably under the management of the current applicant, have there been any problems of the like that are recorded by the presenters since the death of the previous licensee? Do you follow the drift of that? Thank you.
I do. We do, obviously, I work within the public protection team. So even though the premises was not licensed, we do work within a team that deals with complaints about noise. Any complaints about crime would obviously have been reported to the police. So I can't answer on behalf of any criminal reports. As a licensing team, we've not had any complaints since the license lapsed in 2018.
So would it be fair to assume that the objections that have been alluded to by presenters occurred whilst the license was held by the gentleman who died in 2018? Was it 2019?
It was 2018. We were made aware. I don't know, unfortunately, the exact date.
That's fine. Thank you very much.
Any other questions from members of the panel?
There's also the question, I don't know whether somebody else is going to ask, have we got any reason as to why the police have not put in any report or comments? I mean, I think this is the first one I've come across where the police haven't put in some kind of comment either against, for, or neutral. Do we know that if there's any reason for it, Helen? And I realise I'm asking you to look in the crystal ball, but if you haven't, then so be it.
They do reply. It's not in the pack because the reply was a no objection. Okay. So when it's a no objection, it doesn't come before yourselves. Presumably because the number of conditions that are in the operating schedule, the police were happy with.
Thank you. That's fine. Thank you, Chair.
So just to clarify, because when there was an application for the same premise last year, the police did say that explicitly that they agreed to the operating schedule and to the conditions. Have they said that this time?
Yeah.
Yes.
Okay. All right. Thank you. Any other questions, Councillor Hook, Councillor Galvin?
No, thank you. No.
Okay. I think I've got a couple. Let me just find my notes. Yes. What is the law? Are people staying at the hotel able to buy alcohol at an off license, bring it to the hotel and drink there without a premise license being granted?
Yes.
Okay, so there could potentially, even if the application was to be refused today, there could potentially still be drinking on the site. Thank you.
Yes, consumption is not a licensable activity. So yes, anybody can legally buy alcohol from an off license or a supermarket and consume it anywhere as long as it's not covered by a public space disorder area.
Okay, thank you. Several of the objections mentioned the proximity to the river and the danger of the river and perhaps increased risk to people if they're intoxicated. Is there anything in terms of public protection, any conditions that might be necessary or reasonable that could be imposed to ensure that people are safe drinking and leaving and being near the river?
I think that would be a question for your legal advisor and yourselves to come up with. I don't think I could answer that question.
Okay, all right, thank you. I'll ask it later then. Another one of the objectors objected to it because they felt that under this layout, it'd be possible for there to be a bar in the outdoor area and for sales to happen actually outdoors rather than the sales be indoors and then drinks carried outside. Is that the case?
Well, the application is to license the outside area. So theoretically, sale of alcohol could take place outside. For there to be a physical bar built outside, it would probably have to come back to the licensing authority for a variation. Now, whether that be a minor variation or it would probably be a full variation. So if the operator came to us and said, I'd like to erect a bar in the beer garden, there would be another application that would be advertised and would potentially come before yourselves again to be decided. So that there's no bar on the plan, and the plan would have to change if a bar was to appear.
Okay, thank you. So under this current application, sales could happen outside, but through the form of kind of table service and that sort of thing.
Yeah,
only.
or
Okay.
a temporary sort of, a little table could be put up temporarily, but they couldn't put a permanent fixed bar.
Okay, thank you. Another one of the objections, they objected on the basis that if a premise license is granted, that means that music could be played until 11 p.m. My understanding is that it could be anyway because it's deregulated.
That's right, yes.
Yeah. Oh yes, several of the objections mentioned it being on and off sales, but to clarify, it's just on sales being applied for.
I think, yeah, let me just double check. Yeah, it's just on sales, there's no off sales.
Oh yes, and the only other thing, one of the objectors said that, and I'm quoting, York is already well served by bars serving alcohol late into the night and early morning and does not need another. This isn't in the cumulative impact area. That's not something that can be considered.
It's not, no.
Thank you. I just want to, I know that there aren't many objectors actually present today. I just want people to know that we have read the objections and considered everything. So thank you for clarifying those points. Is that all the questions for the licensing officer? Yeah, okay, so we will move on now. The applicant and anyone here on behalf of the applicant can now address the sub.
Well, good morning.
Sorry, I got cut off. You've got a maximum of 15 minutes in total between all of you, please, to present your case and also any witnesses. Thank you.
Okay, good morning, Chair. Yes, this is the application of Clifton Bridge Hotel Limited to license this long established, it was a guest house, it's becoming a hotel, if that is a distinction in terms of works of improvement. The application you are to deal with is the application before you. It isn't the application that was made last year, and it isn't goodness me, the licensing justice's license that was converted by grandfather rights into a premises license in 2005. And it's not necessary for you to start making comparisons between old licenses and current licenses, because your task is to deal with this application, not historical applications. And because we are at a hearing, that means, pursuant to section 18, subsection 1, paragraph B of the Licensing Act, that the authority is already satisfied that the applicant has complied with the consultation requirements. So I know there's been a task set for Ms. Sefton to go off and check that, but it's deemed by the very listing of this application to have been done, and that's not a question that can be reopened otherwise than on judicial review. So putting to one side the irrelevant and turning to the relevant, the basis of this application is set out at page 20 of your bundle in the general description of the premises box. We have a well-established hotel with 14 rooms. It's a small premises. It seeks to provide restaurant seating for up to 43 people, serving mainly residents with pre-booked meals from members of the public. It's going to be food-led. All alcohol will be served with meals only. There'll be no bar service, and an outside area for up to 20 people is what the application proposes. It's a family-run business. The director is Arthur Ferrioli, who is sitting on the right nearest the camera in the other little screen of our team. He's a 50% shareholder of the business with his wife. He is resident at the hotel. He's lived there for some 17 years. So he effectively has a has a vested interest, not just as the business owner, but as a resident, to ensure that this is not a source of crime and disorder and public nuisance. The proposed designated premises supervisor is his son, Daniel. He sits next to him on the screen. Daniel has got a personal license and has held that for some months. As you're aware, the hotel was previously licensed, but that had something of a torrid history under the former operator, lapsed due to non-payment of fees, and then disappeared completely automatically on the death of the previous holder. So the premises have not sold alcohol for some years, and now they modestly come along and ask for permission to do so. The application that you're dealing with today, the only relevant application, seeks only the supply of alcohol, and it seeks it only for consumption on the premises. The premises themselves are defined by the red line on the plan on page 45, and you can see that it includes not just the ground floor internal area of the premises, but also the external area of the premises. And it is within an applicant's discretion as to what they ask to license, whether they seek to license a building for on and off sales and have the outside area not licensed, or whether they seek to have on sales only and license the outside area. There are advantages and disadvantages to either approach, but one advantage here is that this provides a certain amount of regulatory control, that all the offences that you can commit on licensed premises, this operator can theoretically commit on the front terrace. It affords a more control for a regulator when everything is happening within the red line. The hours sought are noon until 11 p.m. We can see that at page 31 of your agenda pack. However, the effect of a condition agreed with the police in relation to a previous application, which has now been re-volunteered, and this is at page 42, is that the sale of alcohol shall cease 30 minutes before close of business on any given day to allow for drinking up time. So the effect of the hours sought together with that condition means that alcohol sales have to cease at 10:30 at the latest. The internal area, turning to the plan, has a reception dining area, and it is the dining area that's intended to be laid out as a restaurant, and indeed already is, chairs and tables and the like. And then there is an external seating area to the front. The external area is subject to conditions, and we can see in particular at page 42, I hope my numbering is right, that the outside area shall not be used by customers for food and drink after 2100 hours daily. So the external area has to be cleared of customers drinking and eating before 9 p.m. on any given day of the week. There is also a ban on external speakers in that area, so there can't be any amplified noise of any description provided in the external area. The management intention of these premises is to use the license to provide drink for people taking a meal within the premises, whether those are residents or non-residents who have booked a table. The management intention is that non-residents who dine will be booking tables. It is not intended to trade this as a public house. Looking at some of the conditions that have been suggested by representors, I should add, it's not intended to trade it as a nightclub either, because some of those conditions appear to have been lifted from nightclub licenses. But this is to be a food-led premises. All alcohol shall be served with a meal. And what we have here is a very extensive operating schedule that begins at page 39 and goes through to page 43 of the bundle. It has to be, for a venue of this size, a very comprehensive suite of conditions that have been offered. And right at the beginning, in terms of the general conditions, the third one is that the premises shall be food-led and all alcohol shall be served with a meal. So residential fears that this is going to become some sort of bar or nightclub are, I would say, without foundation when one looks at what is being applied for, because when one looks at what is being applied for, the applicant has offered a condition that his premises shall be food-led and all alcohol shall be served with a meal. The conditions then go on. Some of these were suggested by the police in relation to the last application. So the staff training condition was a police suggestion. The risk assessment for door staff, including special consideration on race days, was a police suggestion. So far as the designated premises supervisor is concerned, a supervisor's register, that is something that goes significantly further than what the Act requires. The Act simply requires there to be a designated premises supervisor without saying what his or her responsibilities are. But here, responsibilities are imposed upon the DPS, contactable in an emergency, nomination of a backup when the DPS premises license holder is not on site, register, ensuring incident reports. There's an incident book condition, CCTV, again, Chair, that's a police suggestion, a very comprehensive CCTV condition asked for by the police in relation to the application last year that we've agreed with. There are conditions relating to bottles and glasses. No customer will be permitted to take open containers from the premises onto the street. Of course, people won't be able to take closed containers out either, because this is an on-license only application, but the condition is there. Proof of age, challenge 25, again suggested by the police in relation to the application last year and agreed to by my client. Various other conditions, I won't go through this in detail, but conditions in relation to the recording of safety checks, clearing away glasses, first aid, fire safety, the prevention of public nuisance, the closure of the external area after 9 p.m. I've already referred to. That was a police suggestion. I don't think I mentioned that. I think I've dealt with really the other main things there in terms of external speakers. There was a question raised about is it legally possible for us to start selling alcohol from a bar in the external terrace? Well, as a matter of law, you've got to appropriate the alcohol to the contract within the red line. And if the red line is in an outside area, in theory, you can put a mobile bar there and start selling it. But that's not my client's intention. And of course, if my client did start doing that, he would be breach of his condition that the premises should be food-led and all alcohol should be served with a meal. So there seems to be, and it's not uncommon in a set of residential objections, a belief that we're coming along to try and hoodwink the committee, and this is some sort of Trojan horse for a large outdoor vertical drinking operation with mobile bars and hundreds of people standing up and making a noise. But that is not what the application says. The application says the premises shall be food-led and all alcohol shall be served with a meal. The application has set out its intentions in terms of capacity, which is extremely modest. And the applicant has agreed with all the conditions suggested by the police in relation to a previous application, which I don't want to spend a great deal of time on, but was more extensive than this application. The result has been that we have no responsible authority objection to this application. So the police do not object. The police, of course, are your main source of expertise when it comes to crime disorder. The Section 182 guidance says the police, paragraph 9.12, the police should usually be the licensing authority's main source of advice on matters relating to the promotion of crime disorder objective. Well, they're not objecting. Environmental health are not objecting. So when we hear about matters such as risk of people falling into a river, there's no one from environmental health coming along and saying that there is something wrong with this application that means that we can't trust people to exercise their personal responsibility to walk along stretches of riverbank safely.
Mr. Holland,
yep.
you have been speaking for 15 minutes now, so
right.
do you mind wrapping?
I will wrap it up.
Thank you.
The short points, I would say, or the points finally are these. You've got an extremely comprehensive suite of conditions. We hope that it's enough. A useful test as to whether any more conditions should be imposed upon those already offered is a but-for test. Are further conditions appropriate and necessary to promote the licensing objectives going forward, or has the applicant done enough in relation to this modest application? And I would say that it has. Thank you for your indulgence on the time. I hope I'm not too far over 15 minutes now.
All right, well, thank you very much. So there's now time for questions of the applicant. Yep. Each party will have 5 minutes each. Again, so we'll start with Councillor Myers. Do you have any questions for the applicant?
Yes, thank you, Chair. I've just got a couple of questions, and thank the applicant for outlining the application. It was necessary for me to ask about the difference in previous applications, because I just wanted to understand a little bit more about the business plan and how that will affect the community. So that's the
okay,
reason.
Well, can I respond to that, Councillor? I don't agree that it's necessary for you to ask about the previous application. This committee is to deal with this application and not previous applications. So far as the business plan is concerned, that's a matter of commercial confidentiality to my client, unless and insofar as it impacts upon any of the licensing objectives. The business plan, I would venture to suggest that all this committee needs to know is that my client wishes to have a food-led restaurant operation where alcohol will be served with meals only and no bar service for 43 people inside and 20 people outside, which I would suggest is an entirely conventional aspiration in a hotel that has previously been licensed. But you know, I don't think it's necessary, and I certainly would begin to object to saying I need to start putting in business plans and projections and balance sheets and all the rest of it.
Yeah, of course, and certainly not asking for that, and appreciate that you've already mentioned the business plan, the intention to aim for hotel and the perceived improvements within that from it being a guest house. Yeah. A question that I've got is around the subjective nature of what can be described as a meal. Could you outline for me what is a meal in terms of how an alcoholic drink can be served alongside a bag of nuts, a packet of crisps, or a Scotch egg? Is that?
Yeah, well, we had this, didn't we, in the lockdown, that under the 1964 Act, there were certain things that you could do. There were certain longer hours you could have with table meals, and that resulted in lawyers arguing about what table meals were. And there's certainly a 1964 case called Tinsley and Milligan, where sandwiches with pickles were held by the High Court to constitute a table meal. What the applicant has offered is the condition at the third condition. Unfortunately, it's not numbered in the operating schedule, served with a meal. And we deliberately have not defined what a meal is, because bluntly, we don't want to get bogged down in the Scotch egg argument as to whether there are whether we need to start drilling down to whether Scotch eggs count or pickles count or all the rest of it. What we suggest, what the applicant suggests, is that a looser approach needs to be taken to this condition. The premises shall be food-led and all alcohol shall be served with a meal, ordinary words of the English language. And effectively, if the premises is complying with that condition, enforcement officers and indeed residents will know it when they see it. And if it is not complying with that condition, again, they will know it when they see it. And of course, one of the things that can happen, there are various options that can happen when a condition isn't complied with, but one of them is that the license can be reviewed. So if my client is foolish enough to start trading this premises on the basis that the only meals served are bags of peanuts, and a bag of peanuts is shared between 20 people, right? People can come back and apply for a review and say this isn't a meal. But what we don't want to do is to go back to 1964, when we have to start defining what a table meal is, having arguments about Scotch eggs, and requiring all people at all time to have that in front of them on a plate. So the application is what the application is. That's the condition that's been offered. If anybody's got any competing conditions to put forward, I'll certainly happily make submissions in relation to it. But bluntly, we say we've done enough to limit this application in terms of the conditions already offered.
Councillor Myers, do you have any other questions?
Yeah, I've got one more question.
Just because it's been more than 5 minutes, so but I feel it's important that we do hear all the evidence and all the arguments and consider everything. So is your question related to the licensing objectives?
Yeah, I believe it is.
All right, then you can go ahead and ask it.
It's about public nuisance and parking, which doesn't the community doesn't quite understand and would benefit from hearing about where patrons are going to park, visitors and staff at the premises.
That's a planning issue. It's a planning issue. It's not relevant to this committee's determination. So, I mean, if you wanted me to deal with that, I'd require the chair to require me to deal with it, and I'd have to pause to take instructions because I've only prepared for a licensing hearing, not a planning application that I haven't been briefed to do.
I think objectors have said that the planning pressures on, is it Westminster Road, could amount to public nuisance. So I think it is possible to consider it as part of this.
It's a planning issue. Where's the suggestion that somehow this is going to the supply of alcohol in a restaurant that we've already got planning permission for is somehow going to cause a public safety issue or a public, I mean, I'm not sure traffic I don't think traffic can be public nuisance. This is a planning issue.
Chair, would you like any advice on that point, or are you happy with the submissions made to you?
Yeah, so I mean, in some of the objections, that sort of thing that people have submitted, they have talked about parking across driveways and that sort of thing. Can that be called a public nuisance? Sorry, could Victoria just speak?
Thank you. In relation to that, Chair, then obviously we're in the situation of dealing with the alcohol licence, the premises licence today. Regardless of whether or not this applicant succeeds in this licence application, they can still open a restaurant without alcohol, which would still have that number of people. So I would advise you to move on and suggest that it's not relevant to this alcohol application.
Okay, thank you. In that case, do you have any other questions, Councillor Myers?
No, thank you, Chair.
All right, thank you. So Sandra Brannigan, so sorry, can I just check, Victoria, while you're still there? Each representative has the same length of time to ask questions, is that right?
Yes, so there needs to be fairness across the parties, please.
All right, great. So Sandra Brannigan, in that case, you have 8 minutes to ask questions of the applicant.
Thank you, Chair. And I just wonder whether I do have quite a few questions, and I think it would help if I could very respectfully ask Mr. Holland to reply succinctly, because I do have a lot. Mr. Holland, does the applicant, does the DPS, the premises license holder, have any experience of running a licensed premises in a sensitive location?
I'm not sure I'm happy with the way that question's been phrased in terms of the assumption that this is a sensitive location. I think if you're going to ask me questions, planting submissions in the questions is not appropriate. The DPS, as I understand it, has well, we'll ask Mr. Ferrioli Jr. He's certainly had a lot of experience in this particular hotel because it's his family business. I'm not aware that he's been involved in anywhere else. Mr. Ferrioli, can you assist with that?
Specifically in relation to licensed premises, please. And I would say that it is reasonable to ask. This is a sensitive area. It's a residential road where there are currently no other premises. This is a highly sensitive area, and I think the question is entirely legitimate.
Yes, well, I disagree with respect. But Mr. Ferrioli, could you help us with your experience at the hotel, please?
No, not that. No.
Thank you. Perhaps I'll move on to the next question. It seems there's no. I'm getting the impression there is no experience of running a licensed premises.
That was his answer.
Can you tell me where the smoking area is going to be, please?
Outside.
Mr. Holland, you're muted.
I do apologise. I think I'm right that the policy is that smoking is not allowed anywhere on the premises, including the external area. I've seen Mr. Ferrioli nodding his head.
The council statement of licensing policy, paragraph 7.12, says that it is necessary to make clear in the application and assess how the smoking area is going to be positioned away from residential properties. How is this going to be achieved in a residential area when the premises are in close proximity to houses? Where are people going to smoke?
Well, the hotel has been operating there for many years with a no smoking policy. So far as I'm aware, nobody in any of the objections has raised any historical issue with smoking in the past. We've got a small, modest application, and the plan is to proceed with no smoking permitted internally or externally going further forward.
So you're going to prevent, so people aren't going to leave the premises, step into Westminster Road and smoke. People are not going to smoke when they come and visit a licensed bar, restaurant, hotel.
I ask Mr. Arthur Ferrioli, sorry, to explain what happens at the moment in relation to smokers? Where do they go?
Yes, there is an area in the car park that people can smoke, and there's a bin there for defusing cigarettes.
So people are expected to stand in the car park area and smoke. And I note the car park area does not form part of the red line on the premises application. So people are going to smoke in the car park area, chatting, talking in close proximity to residential properties. That's the proposal.
Could I just remind Ms. Brannigan that cross-examination is not permitted without the permission of the...
I don't think I am cross-examining. I'm asking, I'm trying to just elicit information about the smoking area.
A highly leading question, exactly the sort of question one would put in cross-examination.
Well, just trying to establish where the smoking area is going to be and whether it's been thought through where people are going to smoke outside up until 11 p.m. in a residential area in close proximity to properties.
That is...
It's not been considered, has it?
With the greatest respect, the paradigm of a contentious cross-examination question.
Okay, can we
with a submission?
Move on to the
Mr.
next
Holland,
question,
sorry,
Chair.
because there is a cap on the amount of time for questionings, can you please limit your speaking time to answering questions? Anyone can be a representative at licensing hearing. There's no need for kind of training in what is questions, what's cross-examination. The representative has her time to ask the questions, and could you please use the time either to answer or to decline to answer, and then representatives can move on to their next question. Sandra Brannigan, did you have another question?
Yes, I do. So you've said that there are going to be no speakers in the outside area, and so there, I know that regulated entertainment, well, there is no, it's been deregulated, obviously, music, recorded music, amplified music.
Yeah, I've said there's a condition that prohibits the use of external.
Yes, can I ask a question? You said that there are going to be no speakers in the outside area. What's to prevent music noise escape when doors or windows are open? And I know that the conservatory is part of the licensed premises. It's shown on the plans as being a courtyard area, an ice cream parlour. There could be, I'm imagining, but please tell me otherwise, that's not well insulated for noise escape. And so there is loud music could be played and there could be noise escape from the premises.
Yeah, this is an application for a license for the supply of alcohol. It's not an application.
No, I know that, and I know that.
Could you do me the courtesy of letting me finish my answer? This is an application for the supply of alcohol. This is not an application for the provision of regulated entertainment.
I'm aware of that. I'm aware of that, but there will be music on the premises, presumably, and music can escape into a residential area. Do you consider that conditions can be imposed on a premises license in relation to deregulated music? Do you consider as a matter of law that's possible? I think it's a grey area.
Can I say that I'm concerned that I'm getting a string of questions about an activity that we haven't applied to deal with. The only music that could be played in the internal area is background music. We've not come along and asked for regulated entertainment. And effectively, I'm having to deal with points that are being made about an application that I haven't made.
Chair, if I may...
Victoria, sorry. Victoria's come onto the screen. Is that because you wanted to say something?
It was only in case you wanted some advice, Chair.
Yes, I would appreciate some advice. I think it's difficult because the police aren't here. The operating schedule that's been agreed by the police does include conditions on outside music and outside speakers. So presumably that has been considered a licensing issue.
Well, as has been pointed out to you previously, you've no objection and you've no representations either from the police or from environmental health, who would normally deal with the issue of noise. However, it's right to say that the party on behalf of whom Ms Brannigan speaks has raised that issue in their objection, and they have put forward a proposed condition. Yeah. So it is something that was as part of the agenda pack.
I mean, the proposed condition, it's condition 6 at page 76 of the agenda pack, is unworkable. All windows and external doors shall be kept closed between during opening hours, except for the immediate access and egress of persons. That is unworkable when one seeks to license. I mean, it isn't clear whether that's all windows in the entire building or just windows on the ground floor, but it's simply unworkable in a hotel. So far as external doors for egress and access, I mean, again, we're looking at
perhaps, Chair, that's your answer in relation to that question. I'm aware that Ms Brannigan's time is being used.
There's numerous, if one looks at the plan at page 45, there are numerous external doors all around. I mean, to suggest that all of those have to be shut between noon and 11 p.m. At all times unless somebody's using them, just in case this applicant, who doesn't have permission for regulated entertainment, decides to play very loud background music when there's no evidence of any noise breakout coming in the past, and there's no environmental health objection in relation to this application, is
perhaps Mr. Holland, if you could allow Miss Brannigan this time. Yep. Chair, are you satisfied that that addresses the point that Miss Brannigan's raised the question and Mr. Holland has said that it's unworkable in that condition proposed as a representation?
Yes, I think it's raised some questions that I'll ask when we get to the time that panel can ask questions.
Yeah. Thank you.
Yeah, my question was about deregulated entertainment, which is not just background music. The premises would be able to because it's deregulated, they could have loud recorded amplified music on the premises.
Yes, which
so that was my query.
Yeah, your concern, Ms Brannigan, was about that escaping from the premises.
Yeah, yes, exactly.
That's dealt with by your conditioner. Mr. Holland has answered to say, in his opinion, it's unworkable, and they're his instructions.
Well, I mean, in terms of the deregulation, the whole point of the deregulation provisions is not to make it harder for premises to obtain licenses. We can't offer a condition not to have live music that would have the effect of cancelling that out, because the way the Act works is that condition would be ineffective. It's only effective if it's imposed upon a review. I mean, I'm not aware that Mr. Ferrioli has any intention whatsoever of putting on live bands in his 14-bedroom hotel, and he would be slightly commercially brave to have that as an operating plan. But were he foolish enough to do so in such a way that would cause a public nuisance, the license would be liable to a review, assuming that you grant the license.
Chair, would you like to revert to Ms Brannigan for any further questions?
Yes, Ms Brannigan, do you have any more questions?
Yeah, just a couple more briefly, if I may. Thank you. So I understand from the application that the restaurant outside area that's going to be available for the general public. I think for pre-booked, I think the application says pre-booked meals. So I guess that could include stags, hens.
Oh,
Is that correct? Or are they going to be excluded? And if so, how would they be excluded? Because obviously there is a lot of concern about noise in this residential area, and obviously stags and hens, which we have a lot of in York, can be very noisy. So how is that going to be managed?
Mr. Ferrioli, can you deal with how you handle booking?
A security person on the gate allowing large groups not allowing large groups to enter.
pre-booked.
It's purely a family orientated venture I'm doing. It's not, I don't want large groups of people, so they will be stopped at the gate entry.
You have pre-booking system.
Sorry?
You have your pre-booking system.
Pre-booked.
Pre-booking system.
There is, yeah, but booking.com.
Okay. Any more questions?
Yes, one more, if I may. One final one is, I think there's slight concern that the red line area, I appreciate it doesn't cover the car parking area where we've already heard that people are going to stand and smoke. There is also, in addition to what's being described as the outside terrace, there is also a fairly large outside area near the front door of the premises, which is part of the red line. There would be nothing to prevent any of the tables and chairs or outside, or that being used as part of the outside area. Currently, as I understand it, Mr. Holland, do you agree, or what are the proposals in relation to preventing people, because that is getting very even closer to residential properties?
I think if you looked at this plan and thought, what would a malicious operator do to make life as unpleasant as possible for his neighbours, you could come up with all sorts of theories, including putting tables by the main entrance. But the problem that the operator would have if he was willing to do that, and it's very hard to see why he would be, is that the premises shall be food-led and all alcohol shall be served with a meal. Why on earth you'd want to have people dining by the front door of the hotel out of the range of the restaurant, I do not know. But I'll ask Mr. Ferrioli. Mr. Ferrioli, could you have a look, please, at the premises plan at page 45? Have you got that?
So where are you wanting people to sit to eat?
They'll be sitting in the front yard where it's marked.
I mean, we have actually, the notes to completing this form say that you should indicate the outside area where people are going to be. That's obviously normally where it's off sales. We have actually put blue hatching, showing where we want the customers to be. And the blue hatching is not by the main entrance because we don't want them to be there.
But there's nothing to prevent people arriving, leaving, milling around in that area, talking into the evening. That's obviously a concern. You'd accept that?
No, there isn't anything to prevent people being near the main entrance of a hotel that's been on this site for many decades. That's absolutely correct. But what I would say is that this application relates to a small restaurant and a small external area without any facility to use a bar without meals. It isn't a nightclub, it isn't a circuit bar, and I would have thought that the prospect of people milling around by the front entrance and making a noise just on a common sense basis, and the council, the committee of course can apply their common sense but also their local knowledge, would seem, the chances of that would seem to be extremely small to non-existent. That would be a regular occurrence.
Okay, does that answer all of your questions, Ms. Brannigan?
Well, I'll make representations. Thank you. But I
Yes,
just
you'll
have
have the opportunity to do that.
one quick final one, if I may.
It's very quick.
Has the applicant made any attempt to engage with residents to address their concerns prior to submitting this application?
The applicants complied with the regulations in terms of consultation, which is what the applicant is obliged to do. The council is satisfied that the applicant's done that, that bluntly is enough. I don't know if there's some implied criticism in
it's just a question. There's no implications. Just answer it. Thank you. Okay, we'll move on to questions from members of the panel then. If do either of you have any questions for the applicant? Yes, Councillor Hook.
Thank you. It's just reading through all the residents' representations. A lot of them say there's been a lot of police activity in the area recently and things like that. And I know lots of people have very long memories, but is it true that there have been lots of police visits recently?
I mean, I'll ask Mr. I don't live there. Mr. Ferrioli does, but certainly my instructions were that we're unaware of the instances of disorder of which residents speak, and we obviously place reliance on the police objection. It is the case that this hotel is a hotel that local responsible authorities, including this local authority, place vulnerable persons in for short notice accommodation. So there are vulnerable persons, people, the victim of domestic violence, for instance, who have to be rapidly placed somewhere else, and they can be placed here, and they can arrive in a police car with police officers, and it may be that gives a false impression that there is something going wrong on the premises, when in fact the contrary is the case, that the premises is effectively operating as a sanctuary. But I'll ask my client's director, Mr. Ferrioli, if he's got any recent experience of issues with crime and disorder at the premises, because my understanding is he hasn't.
No, there's never been any disorder requiring police assistance, but the police from time to time carry out their job, and if they want to come to Clifton Bridge Hotel to ask some questions about a missing person or other interests that may be concerning to them, I can't stop that from happening. I think every public premises, pubs, hotels, shops, all go through this from the police inquiries, the police wanting to make their inquiries. I can't stop that from happening. But as far as I've been there for 17 years, there's never been any police incidents. There's never been any charges brought on anyone. I've never had any problems at all. But the police do from time to time carry out inquiries. Has to do with many investigations. I don't know what it's about really, but that's police business. It's never affected my premises. It's never affected me. You just have to go on the reviews. If there was anything like that happening, it would be picked up on reviews, and there's no reviews that have been problems with police activity in the area.
Thank you. Councillor Hook and Councillor Galvin, any other questions for the applicant?
No, Chair. No, thank you.
Councillor Hook?
Sorry.
No, that was all. That was
okay,
lovely.
thank you. I have a few questions then. There's currently a bench in the car park with a kind of cover over it. It's kind of covered seating area. I'm just wondering, is the plan for that to stay there? And if so, how will you prevent people from sitting there after maybe having a few drinks, being a little bit noisy or smoking? It's right up against the boundary with the neighbour on Westminster Road.
I'll ask my client to deal with that. I am unaware of
It's a garden trellis that sits two persons.
Yeah.
Easily removed. It's freestanding. It can be, if the next door neighbour was to tell me that she wanted it moved, then I would move it. It's not fixed. It's a movable garden trellis. It seats 2 persons.
All right, thank you. Some bedrooms are included in the licensable area. I was just wondering why that was and what your intentions are for serving alcohol in bedrooms.
I'm not entirely sure why the bedrooms were included. The license sought, and I'm sorry if I'm sounding a bit like a broken record in this, requires the premises to be food-led and all alcohol to be served with a meal. And my understanding is that that relates to restaurant users only. We're not looking to provide room service on the ground floor only with alcohol with those meals. So I think the answer is that the red line has been put around the whole of the ground floor effectively to be comprehensive, but the reality is that those bedrooms are not going to have any alcohol supplied in them.
Okay.
I'm going to just check with my instructing solicitor and my clients that I've got that right, but effectively the red lines around the bedroom add actually nothing in terms of the day-to-day user that's proposed to take place under this license. Is that right, Megan? Yeah, Megan, my solicitor is nodding. What I can do is I can have a little text message chat, and we may be able to simplify that point if it's of concern to you. So I'll just take some instructions.
All right, thank you. Are you happy for me to ask other questions while you do that, or do you need to pause?
Please move on, and I will multitask as best I can on that point.
All right. Yes, so you've said that there isn't an intention for there to be a bar in the outdoor area and for alcohol to be ancillary for food, people to be seated outdoors drinking only with a meal. In that case, would you be happy, if the license were to be granted, would you be happy to accept conditions saying that there'd be no vertical drinking outside and that sales of alcohol outside would be table service only?
Yeah.
I've got an answer on the bedroom.
Yes, great. Yeah, let's go back to the previous question. Sure, yeah, absolutely.
We can exclude the bedrooms from the application if that helps simplify matters.
Thank you. We'll bear that in mind in our deliberations then.
So far as further conditions, Chair, the starting point I make is this: we think we've gone far enough with what we've offered. It's obviously a matter for you and your discretion as to whether you think it's appropriate to add yet further restrictions on top of what we've already offered, if you think that is appropriate to promote the licensing objectives. And there's a certain attraction I can see for having a condition that says vertical drinking. I think the ones you mentioned were table service only, no vertical drinking. Yeah. Were there any more you had in mind?
I don't think I said it, but I was also wondering whether you'd accept if the license were to be granted, whether you'd accept a condition capping the number of covers, either just in the outdoor area or overall. You've said the intention is for 20 seats.
Okay. The current position is I have no instructions to accept any further conditions on top of what's in the operating schedule. And in terms of would I accept a condition, there would need to be a discussion between me and my clients as to whether any further concessions were to be made. My client might want some advice in relation to that, so we might need to break out. But if effectively, my instructions are that we have done enough in the operating schedule, and we're not making any further offers. However, things can move in the course of a hearing if there are matters that are of particular concern to the committee. Dealing with the ones you mentioned, waiter waitress service only or table service only, I can quite see that is very much in line with all alcohol being served with a meal. It may be that I can say that isn't objected to, but I'll have to take some instructions. But I agree that it's difficult to see circumstances in which alcohol could be obtained other than through table service if one had that condition that's already been offered. So far as vertical drinking is concerned, the problem with vertical drinking is that you're talking about the control of customers rather than things that are purely in management control. And there's always the prospect of people suddenly standing up or somebody going along to see somebody at another table they know, and matters of that nature. And the condition being breached and the operator going into effectively a criminal situation by that sort of set of rules. It is not my client's intention to have a large number of vertical drinkers there. It's his intention that there won't be any vertical drinkers. But at the end of the day, that is something that's within the that requires control of patrons, would require if somebody stood up for whatever reason outside, would require management intervention and rushing out and asking them to go and sit down. And we just say that's too much micromanagement for what we're seeking. The same with a capacity number when we're dealing with such low capacities. That if the layout is for 20 people outside and we're at capacity and a friend joins at 21, are we seriously at that point having to refuse that person access in order to comply with the condition? Is that an appropriate and proportionate condition to impose when we've already offered the conditions we've offered? So in terms of the three you've offered, the waiter waitress service or table service probably doesn't add that much to what we've already offered. The other two, what we're concerned about there is not that we want to have a load of vertical drinkers and we want to have 100 people there. If we did that, we'd be sharp brought back on a review, no doubt, by the residents who said, well, they came along to the hearing and told a pack of lies. But we don't think it's necessary for there to be even more rules on top of the rules that we've already suggested.
All right, thank you. Yeah, in our deliberations, we'll discuss we'll discuss absolutely everything and consider what's reasonable and what's necessary. But it's good practice just to make sure everything is discussed in the hearing before we bring it up privately. Right. So yes, thank you for your answers. Are there any other questions from the hearing panel? Is that okay? All right, great. So we'll move on to represent the cases of the representers. So we'll go through the representers in the same order. So Councillor Myers.
Jay, could we just have a 3 or 4 minute break, please?
Oh yes, we have been going for a little while, haven't we? Is everybody all right with an 8-minute break? Come back at exactly 11:30. Oh, Helen, you have your hand up.
Councillor, I was just going to say, you probably need to speak to Victoria about whether it's relevant. I know there's been a big discussion, but I do have the information about the previous application. So maybe in the break, decide whether you want to hear that or not. Yeah. But I do have the information. It's irrelevant.
I think that the panel can decide whether it's relevant or not once we've heard the information. A representative did ask the question, and I'm keen that anyone who does come to these hearings has their questions answered. So I would appreciate that information being provided.
Do you want me to do that now?
Are you happy for us to take a break because one's been requested, and then we'll do that first thing when we come back before moving on to the presentations from the representatives?
Yeah.
Is that okay with everybody?
Yeah.
Yeah. How long a break do people feel like they need? Should we come back at 25 to?
I'm quite happy with 5 minutes or half past.
Okay, 1:30. All right. If everybody could be back by 1:30 promptly, please. All right. Thank you. Is everyone back and the streaming's restarted? Yeah, we okay to go?
Yeah, we're ready to go, Chair.
All right, great. Thank you, everybody, for coming back. So yes, before the break, we said we'd hear from the licensing officer who has some information in response to a question earlier from a representative. I've just used Chair's discretion to say that we can hear this information, and then when we go into deliberations, we will consider everything we've heard throughout the whole hearing and decide what's relevant and what isn't. I'm keen that this information is presented because it was asked for by a representative. That doesn't automatically mean that it's relevant or will be taken into consideration, but I just want to make sure that everyone has had a full and fair hearing. So Helen, are you able to provide the information that was asked for earlier, please?
Certainly, yes. Apologies, I didn't have the information earlier. So the application was fairly similar last year. The main differences I've outlined are the plan was the same, but in the application they stated 40 people would be able to be seated outside as opposed to 20 that we're talking about today. The application also included late night refreshment, and that was from 11 p.m. to 1 a.m. The application also asked for alcohol on and off the premises. And as we've heard today, it's just for on the premises. And the biggest change was the operating schedule was a lot shorter. So the operating schedule that is before you today is much more comprehensive. And I think Mr. Holland has outlined a lot of the agreements that were made with the police. But the main one is that alcohol will be ancillary to a meal. That was not in the first application. So I think in a nutshell, that's it.
Thank you very much. Okay, so we'll move on now to representatives presenting their cases. We'll go through in the same order as we have been throughout the hearing. Then there'll be an opportunity for questions after each representative. So we'll start with Councillor Myers. You have 16 minutes to speak, just so that everyone has the same length of time. That's the length of time that the applicant had. So start when you're ready. You have 16 minutes to address us.
Okay, thank you, Chair. So I'll draw the committee's attention to my and my colleague Councillor Wells' objection, which is, I'm not sure what number it is in the pack, but it's labelled as such, as coming from ward councillors for Clifton, and we object, having received a very high number of objections from local residents and further concern from within the wider community around Westminster Road, Water End, Greencliff Drive, Clifton Green, and slightly wider. The objection is based on the grounds of prevention of crime and public nuisance. Myself and Councillor Wells believe that noise and disturbance is already a problem. This is from our work with local residents over a number of years, but what I should highlight is that does include in recent years. I know the committee were asking those questions earlier. Our concern is that this will become a more regular and perhaps a heightened problem with the granting of this licence. The history of recent incidents does include fights that have resulted in police presence or involvement. Again, that's in recent years. And so it's regrettable that we don't have any police presence in this hearing, or to be able to ask them what the history of reported incidents are, and receive a more catalogued overview of that for your consideration. Moving on to further concerns that have been addressed partially through questioning, but there is limited parking within the area. It's a residential parking zone, and no details to outline how further incidents of prevention of crime and public nuisance, which I'm aware of in in my work in other areas within the ward, can result in police presence. And with alcohol thrown into the mix, then I do feel that that is a factor to consider, as is public safety along the river. It's very poorly lit down by the river, and I appreciate it's not the applicant's intention to see everybody staggering off down the river, but it's a very serious concern that I've got to throw before you as a committee that ward councillors are well aware of, and therefore I raise it again. I think that the biggest anomaly for me within the application is around meals and how long a meal could last at the premises, or what is defined as a meal, or what could it be? I've gone through all these arguments when we did the COVID regulations, and it was ruled that a serving of a single snack, I think is the phrase, permits a meal. And I understand the answers from the applicant, trying to clarify that, but that's all we have at present is goodwill expressed by the applicant, which is welcome, but nothing in terms of either conditions or more specificity within the application. So therefore it's a lack of clarity. I think I'd go back to the overall reason why I'm here objecting is that residents feel that this application's inappropriate for the area. I know we've talked about pre-booking being part of the applicant's proposals, and the use of booking.com has been raised. I've put it to the committee that it's my understanding that the premises does advertise for stag parties to be booked at the hotel. I think that's worth being aware of for the reasons of I think the council overall as a local authority has been very focused on the city centre, how its cumulative impact zone and licensing objectives can be achieved with the prevalence and growing problem, widely perceived problem of hens and stags, but it hasn't applied the same level of rigour to how the hens and stags and other problems related with prevalence of alcohol within communities, how that can be applied to other areas within the city outside the city centre. And I think that's where we're at, in my view, in considering this application. I should say that as ward councillors and many residents will support business improvement and local businesses. It's not an anti-business approach that residents are taking, nor ward councillors, but we feel like because of the lack of specific detail within the application, what is being defined as food-led, or as we've heard, where are the smoking areas, or indeed perhaps the ability to take the community with you and trying to allay the fears of the community by doing more to convince local residents that this wouldn't be a problem should it be approved. And I understand the applicant doesn't have to do that. Just comply with the licensing regulations and what is required when you put an application in. Now, I get all that, but I do feel, and residents certainly feel, that there are risks to this community, this small pocket of area in Clifton, for increased crime and increased public nuisance as a result of this application. It is a residential area. I do consider it a very sensitive area. There's a lot of many families. There's a lot of elderly residents too, and it currently is very quiet. And combining that with what I've just spoken about in terms of the city's wider goals in terms of the impact of alcohol on residents and their lives, their health and their well-being, and the strength of communities. At present, I'm outlining all the reasons why and concluding that I feel that the committee has to reject the application. Thank you, Chair.
Thank you, Councillor Myers. So, in turn, there's now time to ask questions of Councillor Myers as a representative. So, does the applicant or anyone who's here on behalf of the applicant have any questions for Councillor Myers? If so, you have a maximum of 5 minutes.
No questions.
Thank you. Then, Ms. Brannigan, do you have any questions for Councillor Myers? You also have 5 minutes.
No, thank you, Chair.
All right, thank you. Members of the panel, do you have any questions for Councillor Myers? Councillor Galvin, go ahead. You're muted, Councillor Galvin.
Sorry. Councillor Myers, I assume that you are aware that in the event that the panel was to refuse this licence, the applicant would have every right to appeal to a magistrate's court, and given the kind of evidence and the information that we've received, it's fairly odds-on favour that a licence will be granted by the magistrates. Would you accept that that's a possibility?
Yes, of course, I accept it's a possibility, but for reasons I've outlined, I believe there's a robust case to defend the residents and the objections that they've raised in this application.
Thank you. Thank you.
Councillor Hook, do you have any questions for Councillor Myers? No, okay. I think I only have one, and I'm going to preface this by saying that we will, when we go into deliberations, we will ascertain what's relevant and what isn't, and take legal advice on that. But you've raised parking pressures as part of your objection. One of the objectors, not yourselves or Councillor Wells, but a local resident, has said that they're particularly concerned about parking pressures in the evening because parking's unrestricted after 6 p.m. Now, I've checked what the residents' parking is, and it doesn't mention anything about restrictions only being until 6 p.m. I was just wondering if you know anything about that. Or the signs on Westminster Road just say residents' parking.
Yeah.
10 minutes
Offhand,
only, doesn't, yeah.
Offhand, I don't know, Chair, actually, to be able to give you a definitive answer on that. There's varying patches of bays along the neighbouring streets with some slightly different times on. Okay, thank you. Yeah, I was just trying to ascertain what that objection, what point they're trying to make, just so if they're watching, they know it's been addressed. But that's fine. I think that looks like all the questions for this representative, so we'll move on to the next one. So, Sandra Brannigan, you have 16 minutes to present your case.
Thank you, Chair. Just in relation to that point about residents' parking zone, my understanding is that along Westminster Road itself, there are varying restrictions, and it's not the same all the way along Westminster Road. I think that might be. Just to mention, pick up on a point that's made by the applicant in relation to conditions, just to remind the subcommittee that the test is, of course, what is appropriate, not what's necessary, and it's what's appropriate to prevent I'm making a representation about prevention of public nuisance, so it's what is appropriate, what would be appropriate to prevent a nuisance. And the applicant has suggested that what is being proposed would require additional conditions. I don't think that's really necessarily the case if members were minded to grant a licence, because I think it's a question of looking at the operating schedule that's been proposed and converting that into appropriate conditions. Indeed, the statutory guidance tells us in paragraph 10.5 that it is not acceptable for the licensing authority to simply replicate the wording from an applicant's operating schedule, and that it is necessary to interpret conditions, impose conditions in accordance with the applicant's intention. And of course, the applicant's operating schedule does state that it is intended that, for example, there would be 45 persons inside, only 20 outside. It's perfectly reasonable for the committee to convert that into a precise and robust and enforceable condition on the operating schedule. Indeed, the guidance suggests that that's what ought to happen. Also in relation to conditions, comments were made about vertical drinking. My understanding is it's a fairly standard condition to have a no vertical drinking condition. Your licensing officer will no doubt be able to advise you as to whether or not the licensing authority have any issues related to the enforceability of such a condition, or it causes enforcement issues because it was suggested that it would just not be workable. Also in relation to having a condition about maximum number of covers, having customers seated. Again, my understanding is those are fairly standard conditions on a restaurant style operation, which is what the applicant claims this is. Again, your licensing officer will be able to advise you, no doubt, as to whether or not they experience that there are any enforceability issues with such conditions, because it's been suggested by the applicant that these conditions just aren't workable. As I've said, my representation relates to public nuisance specifically, and I think it's important to focus on what this application is for. It's for an indoor-outdoor food, drink development in a quiet residential area which has no other commercial premises. So we're introducing a new premises license into this quiet residential street. I'm not surprised that the police haven't made any representations in relation to public nuisance. That's not their role. And in public protection, haven't made a representation, but that is, I'm guessing, I don't know, of course, I have no idea, but of course they focus on statutory noise nuisance. And given that there is no music is deregulated, they probably, and therefore music is not applied for, that might well explain why they have not made a representation. It is concerning that the applicant has made no attempt to engage with residents prior to submitting this application, even though he will be aware from the previous application that there are very strong objections locally from residents, and they're very concerned about this. This doesn't seem to bode well, this sort of unwillingness to engage meaningfully with what will be close neighbours, other residents, especially not when the applicant is proposing to introduce a new licence into what is a quiet residential area, and it is inevitable that there are going to be problems. I'm not at the moment persuaded that there is any evidence that there is any real intention being demonstrated by the applicant that it intends to be a good neighbour and engage meaningfully with residents going forwards. It's also extremely concerning that the applicant has not carried out, but it was a basic requirement to undertake a risk assessment, in particular in relation to the smoking area. It simply hasn't been thought through. The area where I understand from answers given by the applicant that customers will be expected to smoke is not part of the red line area of the premises. So it seems very difficult to see how this could be controlled by what would be expected to be, I would say, reasonable conditions on a premises license in a quiet residential road, for example, numbers of people in the smoking area, regular monitoring to make sure no nuisance. It's very worrying that there could be numbers of people congregating in that area smoking, bearing in mind this is in close proximity to residential properties. Even two people out there talking in a quiet residential road is going to sound like 20, 30. It is such a quiet road in the evenings particularly, and voices will be heard even if people aren't shouting. The council's own statement of licensing policy makes it clear that public nuisance is not narrowly defined, and it can include low-level nuisance affecting just one or a few persons living locally. It's paragraph 7.11. The statutory guidance also says that nuisance can arise when the amenity and environment of people living in the area is reduced. And the guidance also makes it clear that it is for the subcommittee to make decisions in the overall interests of the local community. So the commercial interests of the operator are not the relevant consideration here. The promotion of the licensing objectives is the relevant consideration. It is the only consideration. And I'm addressing you in relation to the public nuisance objective, and the objective is the prevention of public nuisance. So the subcommittee's role, as you will know very well, I'm sure, is to use your common sense to make judgments, inferences about potential harm and what is appropriate to avoid it. And the standard is the balance of probability. What is going to happen if the license is granted in this location? In this case, we're talking about an application for a new license, so inevitably representations have to be speculative. And what members need to do is, in effect, carry out a risk assessment as to what is likely to happen. And the subcommittee are being asked to authorise an indoor-outside operation in a quiet residential road. So there will inevitably be noise associated with the proposed use. We're talking about up to 45 covers indoors, up to 20 outside, hotel guests, staff, unrestricted numbers out congregating outside in the what's going to be the smoking area. Means there could be a significant number of people on and around the premises at any one time, from midday to 11 p.m. every day. Voices don't need to be, people don't need to be shouting, but there will be loud voices, alcohol related, just people coming and going, taxi drop-offs, Uber drop-offs, pickups, engines running, stag hen parties, the arriving, coming and going, extra footfall, the smokers, just people loitering, talking outside, extra cars coming and parking, doors slamming, engines running. It isn't a stretch to conclude that there is a real likelihood that all these goings on will reduce the amenity and environment for residents in this location. It's going to have a real negative impact. I mean, residents obviously will tolerate occasional noise from their neighbours, but noise from a commercial premises on a regular basis is unacceptable. So there is going to be a material and negative impact on residents. If I may turn, Chair, to the applicant's operating schedule on page 39, which the applicant has says is comprehensive, and it is lengthy, but I would submit that it is all rather woolly and rather vague. We don't know what's going to happen with the outside areas. There is nothing to prevent vertical drinking indoors and out, nothing to prevent customers loitering, smoking, talking loudly. There's no requirement to regularly monitor the situation outside. There's talk about a litter pickup regularly. Well, shouldn't there be a litter pickup at least every day? This is a residential street. The smoking area needs to be positioned away from residential properties. Where and how is this going to happen in a residential area? There needs to be a robust restaurant condition with alcohol ancillary to a meal. One has been proposed in the representation that I'm speaking to. Food-led is very vague. There is no current requirement for table service only, nothing to prevent the vertical drinking, nothing to prevent a temporary bar outside. no maximum amount of covers inside or outside. The decked area, I would add, is very large, and as we've just heard from the licence officer, that the previous application was for 40 covers outside. So the area outside could easily cover, I think it could easily accommodate at least 40 covers. I know that I think 20 are now proposed, but there's nothing to actually restrict more people outside. And we're talking about an outside area in close proximity to residential properties, which will cause a noise nuisance. I think, Chair, that I don't really have any more comments on the particular operating schedule. It's safe to say that I don't think that it is robust. As I have previously mentioned, it is entirely appropriate for members to convert what is in the operating schedule into robust and meaningful and precise conditions. There are conditions that are proposed in the representation that I am speaking to. There is what I believe to be a fairly standard restaurant condition. If the applicant is, as they tell us, only intending to be a restaurant, only intending to be alcohol ancillary to a meal, only want to have 40 people, well, why can't this be, why can there be any objection to this being conditioned? It doesn't really make sense not to condition it or to object if that is what is genuinely proposed. I think, Chair, I will leave my submission there.
Thank you very much. So in that case, there's an opportunity for questions. If the applicant or anybody who's here on behalf of the applicant has any questions for Ms. Brannigan, you have a maximum of 5 minutes.
No questions. Thank you.
All right, thank you. Councillor Myers, do you have any questions? Okay, members of the panel, any questions? Okay. So you suggested some tightening up and sorry, I can't remember exactly what words you used, but you talked about the operating schedule and changed conditions. If those conditions were in place, food ancillary to meal, table service only, cap on the number of covers, no vertical drinking, would this application be acceptable?
No, it wouldn't. I mean, those are conditions which I should make clear. I was simply responding to the applicant's point that we can't change the conditions, or they can't be somehow reworded, and it might be unreasonable to do that. I don't consider that a license in this area will or that any conditions could be imposed which would prevent a nuisance in this area, because it's not just talking about, okay, 20 people in the outside area, only 40 people indoors, but in this location, even with such conditions, there is inevitably going to be a noise nuisance and disruption and a reduction in amenity for residents, just because of all the comings and goings and activities associated with a licensed premises. I think the point is that this is just inappropriate location for a licensed premises, because I think there is inescapably going to be noise, just disruption, footfall, people talking, what we've talked about, smokers talking, noise, just the general noise that you would get, and with increased activity and footfall and traffic associated with a licensed premises in a very quiet residential area.
Could you explain more why you feel that extra noise and footfall would be as a direct result of the licensable activities rather than as a result of it being a hotel and restaurant?
Well, I think
that can play music and have people on the premises anyway.
Well, because they have advertised that it is going to be, people will be attracted because there's going to be alcohol, and they are proposing, according to Councillor Myers' representation, they advertise stag and hen parties. They say in their operating schedule that they are going to have pre-booked meals. So there will be people arriving and coming and going. There will be increased footfall and activity in this location as a result of what is being proposed by the applicant, because they are having an alcohol license that will attract more people. And of course, when people drink, they talk more loudly as well, including existing patrons of the hotel and residents. People congregate, they talk loudly. There'll be taxi pickups from the people coming from the restaurant, and people hanging around and talking loudly. I mean, another point in relation to the use of the outside area. One of my concerns about what the condition simply says that there shall be no eating and drinking in the outside area after 9 p.m. I think that's the wording. Whereas I think it would be more usual and more robust to actually close the outside area to customers, because there is the prospect that people can still, they might not be drinking and eating, but they can still be talking there into the small hours. So it is more usual in a licensed premises, I think, to close the outside area after a certain time.
I actually had that on my list of questions for when we have clarifications at the end. So are there any other questions from the panel for Ms. Brannigan? Okay, all right, so we'll move into the summaries. We'll do this in a slightly different order from how we've been doing the rest of the hearing, because the applicant always goes last. So we'll, Councillor Myers and then Ms. Brannigan and then the applicant will all have 5 minutes each to summarise in that order. So Councillor Myers, could you, go ahead.
Thank you, Chair. I'm not going to repeat myself. I think that in my representation, I've already summarised the reasons why residents feel there should be an objection to this application, and the more the hearing goes on, I've got to say the stronger those pieces of evidence become, and I hope that's clear to the committee. Thank you, Chair.
Thank you very much. Ms. Brannigan, you have 5 minutes to summarise as well.
Thank you. And we've heard that the applicant, the DPS, the premises, the personal licence holder, has no experience of running a licensed premises, let alone a licensed premises in a sensitive area such as this, quiet residential area. The applicant has not attempted so far to engage with residents prior to submitting the application. So this is very, very troubling as to the applicant's general, I think, approach and how issues may be resolved, and whether this is going to be a considerate neighbour. There is no proper risk assessment in relation to the smoking area. The application simply does not consider the nature of the location and the character of the area. It's just simply not suitable for the area. The proposal 7 days a week up until 11 p.m. is inevitably going to introduce an unacceptable noise problem into a quiet residential area and reduce the amenity and environment of people living in close proximity. That is a public nuisance in terms of the Licensing Act, which the committee, subcommittee has a duty to prevent. Local residents in this location do have an expectation of quiet enjoyment of their homes. This is not a city centre location, or it's not, we're not talking about Bishy Road or another location in York where it might be argued that there is an expectation of a certain level of noise and disturbance. This is a quiet residential area with no other commercial premises. The guidance makes it clear that promoting the licensing objectives in the overall interests of the local community is a relevant consideration. Indeed, as I've said, promotion of the licensing objectives is the only consideration. In my view, conditions will not be able to adequately address the disruption and nuisance that will inevitably follow from the grant of an alcohol license in this location. And the conditions which have been proposed as part of the representation I'm speaking to, those are just examples of robust conditions which could be imposed if members are minded nonetheless to grant a license. But as I've said, I don't consider that it would be possible to really impose conditions that would prevent a nuisance in this location. Thank you, Chair.
Thank you. So finally, the applicant or anybody who's here on behalf of the applicant, you now have 5 minutes to summarise.
Thank you, Chair. Well, the starting point is that this is a long-established hotel operation that's been trading under my client's control for getting on for nearly 2 decades. But furthermore, has got a very long history of licensed user. It's a premises that had the benefit of a justice's on license. It's a premises that had the benefit of a premises license under the 2003 Act. And to listen to the representations, it's as if my client's coming in with a completely novel suggestion, whereas in fact, this application is to restore what was there in the past and was there for many, many years. It's entirely appropriate location for what my client seeks to do, because it has a long history of being used for these very purposes. There is no police objection to the application. The only person who's spoken today with any direct experience of what the premise is like is my client's director, who's lived there for 17 years. He's not aware of incidents of crime and disorder and public nuisance, and nobody has been able to give you a single particular in terms of a date and any description of what is alleged to have been happened of anything adverse happening on this premises at any time. And I think the inference you can draw is, or the inference you should draw, is that there is no evidence of crime and disorder and public nuisance emerging from these premises before you. There's no environmental health objection, and environmental health, certainly my experience in this local authority, are not shy of turning up when they think there's a problem, even if that problem may not cross the threshold of statutory nuisance. I've already said that things like parking is irrelevant. River safety, I completely agree. It's a very, very serious matter. And I know of other local authorities further up in the northeast that have a big problem with it, but it is not a matter to be dealt with by excluding this applicant from the market. It's a matter to be dealt with at the riverbank. And essentially, in my submission, what we've heard today is pretty much a catastrophic lens that you're asked to view this application through. The fears that residents very often express to applications have been hyped up before you today in dealing with this application. And it's completely unreasonable in my submission to suggest that a small 14-bedroom hotel that has the temerity to come along and ask you to offer something along the lines of what it used to offer in the past is somehow going to be the cause of the sort of nightclub slash circuit bar slash music festival style crime and disorder, public nuisance and risk of public safety. That's being described in the representations amplified for you today. The test is under hope and glory, what is reasonably appropriate in this area, applying a light touch and bearing in mind that if the premises does not promote the licensing objectives going forward, it can be brought back for review. And in my submission, what you should do is to grant the license as sought. So far as conditions are concerned, it's fairly obvious, certainly so far as Miss Brannigan's client is concerned, that whatever we offer, that is not going to be enough. There's still going to be an objection. But the pandemic, the recent pandemic in my submission, has demonstrated the unreality of trying to define what is a meal. Miss Brannigan's clients or the person for whom she speaks wants to have a definition of a substantial table meal, which is not a creature known to law that I'm aware of, but all sorts of arguments about Scotch eggs and all the rest of it. Effectively, what's being sought is to try and add conditions, taking this back to the 1950s, if not earlier. But what we say is that we've gone far enough. We've taken on board the police's suggestion. I realise I'm now over 5 minutes, but I'm going to just be very, very brief in closing. But there has to come a point when a balance is struck, rather than having a suite of rules of such complexity and such detail. They're more appropriate for a nuclear power station than a small restaurant of this place. And I do say, finally, that a but-for test, that really, in terms of conditions, you need to be asking yourself, if we don't put this on, should we be refusing, is a useful test to bear in mind, given the review facility.
You have been over 6 minutes now. Yes, thank you. It sounds like you've drawn to a close. Yes, thank you for spotting that. I was making notes instead of looking at my timer. Okay, so that's everyone's summaries. Before we finish, I would just like to ask the applicant, I know we've discussed this as we've gone along, we've discussed potential conditions if the license were to be granted. I just wanted to check whether you have any final comments on any of the proposed conditions, any proposed amended conditions or new conditions that we've been discussing during the hearing. This isn't a prejudgment of whether it will be granted or not, just that it's helpful in our deliberations to check whether there are any issues with the wording or the principle of any conditions before we move into deliberations.
Well, I think I've made, I think I've, unless there's anything you want me specifically to deal with, I think I've made the points I wanted to make. My application is the application as set out in writing in the operating schedule.
Okay.
And I say that's enough.
Okay, thank you.
But if you wish to go further, then that is, of course, a matter for you.
Yes, it is.
I'm not going to start suggesting. I did think about whether it would be helpful for me to start drafting things that I didn't agree with, but if you wanted to impose, you could impose. And it just seemed that I was slightly going down the rabbit hole in doing that.
That's fine. We will
have the benefit of legal advice. I'm sure that Mrs. Wardby can assist you in that regard.
Yes, absolutely. Yes. When we're deliberating, we'll discuss.
I mean,
no, that's all right. That answers the question. Thank you. Okay. So then just the final thing to do before we move into private deliberations
Chair, can I just raise one issue?
Yeah.
What I'm not clear about is what the applicant is intending to do with the plan. Does the applicant can I just speak first, please, Mr. Holland?
Sure.
Is the applicant intending to submit an alternative plan with the 4 bedrooms on the ground floor removed, or are you maintaining the current plan?
Let me just check what my instructions are. And my instructions were the bedrooms can be excluded. So if you wish to exclude the bedrooms from the licensed area, I'm happy to agree that. If it would make life easier, I can withdraw that from the application. But obviously, I can't start drawing on a plan and,
No,
and
I
handing
just
it to you
I
because
just need
we're
to be
all
clear. I just need to be
remote.
clear what the members are going to be determining. Are you saying that you will amend the plan, or you're not going to amend the plan? Which plan do you want the members to consider, with or without the ground floor bedrooms?
Shall I take some instructions on
Yeah.
Because if we're excluding them, I need to know exactly where the red line moves to. Miss Waldron.
Yes, it looks like they're having a quick discussion around the table.
Right. Well, I've been told something that doesn't answer the question. I think the simplest thing is I will make the application as made.
Thank you very much.
And if you think that it covers, you are entitled, if you think it's appropriate, to grant it for a smaller area than the area I have applied for.
All right. Okay.
Your submission is the plan is retained. Thank you very much.
Okay, so in that case, just the final thing to do before we go into private deliberations, I just want to check with my fellow members of the panel if there are any final points of clarification from anyone, from any of the representatives or legal advice or the licensing officer. Yes, Councillor Galvin. Oh, no, you're still muted.
Can I just get some clarification? My understanding is that this has been run as an hotel and dining for a number of years. I'm not sure whether public were able to book tables, but can somebody confirm that, excluding the drinks license, which this is what it's all about, the establishment could continue as a restaurant and presumably take bookings for members of the public other than patrons of the hotel? Do I make myself clear?
Yes, I think so. I mean, you're asking, is there anything at law to prevent this property being traded as a hotel with a restaurant, where the restaurant can cater to non-residents? And the answer is, so far as I'm aware, no, there's nothing at law to stop that happening.
Thank you.
Are you interested in what it's been doing in the past, Councillor?
That's fine, thank you very much.
Okay. Any other final points of clarification from Councillor Galvin or Councillor Hook? Okay, I have a few just final points. A question for the licensing officer, if Helen Sefton still here. Were there any responses from public protection? It was raised earlier in the hearing that sometimes the premise is used for housing vulnerable people, such as people, immediately escaping domestic violence and that sort of thing. Did public protection raise anything? Do you know if they were aware of that, and did they raise anything from a protection of vulnerable people point of view?
I think they are aware, and they didn't raise any representation along those lines.
Okay, thank you. A question for the applicant or anyone on behalf of the applicant. So there's a condition saying that the outdoor seating area won't be used after 9 p.m, but it's also been raised in the hearing that you don't want any conditions that involve micromanaging people's behaviour. So in what way will the outdoor seating area be closed, and will it be made clear to guests that they can't sit out there with food or drink?
That condition was drafted by the police. So that was a condition the police asked for in relation to the application last year, and it's one my client agreed to. In terms of how that is complied with, that is a matter of management. I don't know if Mr. Ferrioli can assist as to how he's going to manage the terrace after 9 p.m. Is it going to be cleared of people consuming food and drink, or is it going to be totally closed? And I don't know if he's listening to me, because I can see he's talking to my solicitor as well. But I'm not managing the premises. I'm merely their lawyer. It will be a matter for Mr. Ferrioli to manage, unless, of course, you impose a different condition. But can we have any clarification from the managers as to how they are going to manage this, please?
Yes, I just spoken with Mr. Ferrioli. Apologies, he is hard of hearing. That's why I've been trying to relay the question to him. It is something that he will be monitoring in terms of himself, staff, and the DPS, and there'll also be clear signage. So it'll be monitored by management and staff. Okay,
so the outdoor area isn't going to be physically closed, furniture stacked, everything like that.
The external gates will be locked into the garden area. The whole area will be locked off.
I don't know if you can hear that, but
yes, we heard that. Thank you. So it will be physically closed,
yes,
not used for people who aren't drinking or eating.
Yeah, the gates have a lock on them, so they will be locked.
Okay. Thank you. I have a question for the representatives, Ms. Brannigan and Councillor Myers. Quite a few times during this hearing and in objections, the phrase 7 days a week was used, and people having an issue with the licence being granted until 11 p.m. 7 days a week. Are there any particular days of the week that raise particular concerns? If either of you would like to answer, then please do just unmute yourselves and jump in.
Well, I'll speak first as our microphone's on, Chair. I think the concern is it's just the constant noise, isn't it? It's just having an operation there constantly, as it were, every day. That it's the constant noise nuisance. That's the problem. That's what's going to be a problem for residents. As I said in my submissions, that an occasional barbecue and neighbours, having people tolerate occasional noise from neighbours, but it's the constant noise from a commercial premises that's going to be the issue.
Okay, thank you. Councillor Myers, did you have anything to add to that?
Yeah, thanks, Chair. I think it just needs answering by saying, I think as a committee, you need to consider the residential amenity, as I've outlined, residents' health and well-being. And again, I'll make the point that I guess it doesn't matter on what day of the week a stag party is staying over at a hotel in a sensitive residential area, but those are the very real concerns of the residents.
Okay, thank you. And I think my final point of clarification is for the applicant or anyone on behalf of the applicant again, and it's this issue of a meal. And I know you don't want to get into a full legal debate about what the definition of a meal is, but I just wanted to check that your intention isn't to, serve a pint of beer as long as they buy a packet of crisps, for example, or continue to sell future pints of beer if people have bought one packet of crisps, that sort of thing. That you do intend to comply with the spirit of the law, even without getting into a debate of the exact limits of the law.
Yeah, I mean, the condition is that the premises shall be food-led and alcohol shall be served with a meal. I think if what people were getting was a bowl of rice crackers and 8 pints of Stella, it would be hard to argue that the premises were being food-led, or indeed that was a meal. I think where apologies, you probably already have the point. It's the hair-splitting, rule-writing 2020 throwback as to defining exactly what a meal is something that we say is currently unnecessary. One could see that in a problem premises it might become necessary at a future point in time, but it's inappropriate at this stage. I do know that the client has spent something in the region of £50,000 on a kitchen refurbishment as part of the improvements to the dining area, and they haven't done that with the intention of giving people crisps. They want to make money from selling food because the market is food-led. But as for their specific intentions as to kind of menu and things like that, I think I'm going to have to defer to my client and see if Mr. Ferrioli can provide you with any further assurances as to what he hopes to do. There may already be food being provided there.
And you already serve that, don't you?
Sorry?
You already serve that.
No, I do. That's sort of confused.
The intent, at the moment, the hotel does serve full food. The menu is changing to a more of Italian because that's Mr. Perio's heritage, but it is full meals, set meals, breakfast, lunch and dinner.
Generally doing buffets.
I don't know if we need those, but thank you.
Chair, you're on mute.
Oh, it was bound to happen eventually, wasn't it? Any final points of clarification from anyone else on the panel? No. Okay. All right. In that case, I think we're done with this public hearing. We'll withdraw. The panel will withdraw to consider our deliberations and decision in private session. We're not going to return to this public session to announce our decision today. So the other parties are no longer required to stay online. The decision will be communicated in writing to all parties and announced on the council's website within 5 days. So thank you everyone for your time today.
Thank you, John.
I'll call this meeting to a close.